What's up, guys? Brian Fell Law Group PLLC here with your Florida Law Weekly case update. I got 5 cases for you. Let's get right to it. First case is Dore versus Baptiste. This has to do with imputing income for purposes of child support or alimony. A lot of times we always just assume, hey, go ahead and impute minimum wage. Not so fast, my friend, like Lee Corso used to say. Just because somebody has the ability to work doesn't mean you automatically get to impute minimum wage, particularly if there's a case where there's child responsibilities, caretaking responsibilities. So, for example, if there's like a stay-at-home mom or somebody like that who has to take care of, in this case, it was multiple children, it's like 4 or 5 different kids. That has to be considered when determining if she is voluntarily unemployed or underemployed. So you can't just automatically say, hey, everybody's got to work. Not necessarily. If you're taking care of kids, you might not be imputed full-time minimum wage. Very, very important thing to know and remember in cases like that. Next case is out of the 3rd DCA. This is an interesting case. It has to do with an attorney in a guardianship proceedings. She was appointed as the guardian's lawyer, basically, the ward's lawyer. And she was deposed because of her attorney's fees. They were determining how much attorney's fees she was going to be awarded. And during her deposition, it came up that she had previously seen essentially like a psychiatrist because, and I think she testified, because of this case. It was causing stress. It was causing stress on her relationship with her husband. And so the opposing counsel said, oh, hey, you opened the door. Now I get to have discovery and interrogatories as to who is your, counselor? Who is your psychiatrist? What kind of treatment are you under? Things like that. Again, no, can't do that. She did not open the door. The reason is the scope of relevancy in this case is framed by the pleadings. So just because she testified to something at her deposition, that doesn't mean that it's open door and that all of a sudden anything regarding what she testified to is relevant. It has to do with really confidentiality. Patient, there's a privilege, of course, in Florida law where in medical records, and that applies to psychological records. Those are privileged unless they're relevant to the proceedings, and this is not relevant to the proceedings as framed by the pleadings. Next case is Torres versus Melendez, and this has to do with an income deduction order. We always assume in these family law cases you can get attorney's fees included in your income deduction order. Again, not so fast. Why? Well, it has to do with, in order to put it in the actual income deduction order, the fees have to have something to do with the either establishment or collection or modification of child support or alimony support. It has to do with support obligations. So it can't just be all your attorney's fees get included in that income deduction order if there's some sort of payment plan. Next case is a divorce case, another interesting one. Okay, so get this. So this is out of the 5th DCA, brand new case, came out today. It's SMITH-FULLERTON versus Fullerton. And in this case, the judge who presided over the divorce case for like 16 months or something like that ends up retiring and then goes and works for the husband's law firm, the law firm representing the husband. So it was a disqualification case where the wife moved to disqualify the husband's entire law firm. And there was a couple key things here. If anybody ends up having a case like this, it's probably pretty rare. But in this sort of situation, it could be a mediator or any sort of third-party neutral who ends up retiring or going and working for the law firm of one of the parties. You have to provide notice to the other side. You have to provide written notice that, hey, I'm now working for, your opposing party's law firm. That's a requirement in order for the firm to remain in the case. Another key thing here is, you have to be walled off and you have to be screened. And so you can't have any information regarding the case when you're working there, right? The judge can't have any new information. It has to be screened. Well, in order to prove that, in this case, there was a hearing at which the law partner was not sworn. In order to testify, you have to be sworn. You're not a competent witness if you are not sworn, even if you're a member of the Florida bar. So again, attorneys talking in a court hearing, that does not mean it's testimony. That's not testimony. Testimony has to be under oath. So all that testimony that this gentleman, this partner gave, not good, didn't count. It's like that the commercial did not count. So that case got reversed and the firm got disqualified. Last case it's not really a family law case. It has to do with probate, but I thought it was interesting because we have these issues a lot. Homestead and a revocable trust, not an irrevocable trust, a revocable trust. You can still have homestead protection on a revocable trust, and that property that's titled in the name of the revocable trust is outside of the probate estate. It's property of the trust. So in this case, the court erred by allowing the creditors to come after this house, even though it was homestead, because they thought that, I'm sorry, this was actually affirmed. So the creditors were not able to go after the trust. They're not able to go after the property because it was properly determined to be the homestead property, and then that homestead protection goes to the heirs, and the heirs, not just surviving spouse and minor children pursuant to another section of the homestead law. That includes all the heirs, which includes the adult children in this case. All right, guys, that's it for this week. Hope everybody had a great weekend. Hope everybody has a wonderful weekend. Take care.